Welcome to today's episode of In the Trenches. It's a new McDermott Health podcast on health policy and enforcement issues impacting the health industry and how it does business. I'm Mara McDermott, Vice President with McDermott Plus Consulting, and today I'm going to be speaking with Brian Simpson and Satya Thalam on the rulemaking functions of the Office of Management and Budget, the Department of Health and Human Services, and the Biden administration's approach to Trump-era policies, and much more. All right, well, Satya and Brian, thanks so much for being with me today. If you don't mind, I'd like to just take a couple minutes to orient our listeners to who you are. So we'll start with a little bit of introduction. And Brian, I'll pick on you first. Give us a little bit about your background, who you are, and your new role at McDermott Will.
Sure. So I'm a litigator by trade. I tell people that, and they don't always believe me, but I was a litigator in Atlanta for 15 years, serving healthcare clients in False Claims Act cases and reimbursement disputes before I joined HHS as the principal deputy general counsel there back in 2017. And I served at HHS through October of 2020 and had a wide variety of roles in the Office of General Counsel. And perhaps the part of my role most relevant to today was advising principals at the department on rulemaking procedures and on specific rules, and then on the litigation that arose out of those rules. I joined McDermott after concluding my service in January of this year and focus my practice now on the Administrative Procedure Act and healthcare fraud enforcement defense. And I'm delighted to be here.
Great. Well, we're delighted to have you. And we are also delighted that you've brought an old friend from the administration along with you, and we will let him introduce himself next. So Satya, I'll hand the virtual microphone over to you.
Thanks, Mara and Brian, for having me. My name is Satya Thalam, and I was most recently at the Office of Information and Regulatory Affairs within the Office of Management and Budget, which itself is a component of the Executive Office of the President. That Oira, as we call it, oversees regulatory policymaking across the entire executive branch. Before that, I was at in the Senate Homeland Security Governmental Affairs Committee, which we affectionately call HISGAC. And there I oversaw most of the legislation that had to do with regulatory process, which is why I ended up at Oira in the first place. Before that, I was kind of bouncing around think tanks and academia, and generally consider myself an ad law nerd, which is a large but very passionate cadre of folks in the policy sphere. But right now, I'm an executive at a company called EQRX, which is a biotech, biopharma company developing biologics and with a mission to introduce new therapeutics for oncology and other conditions at radically lower prices. So excited to be here with you guys today.
Great, thanks. I'm going to stick with you for a second because you launched us into an alphabet soup. I don't know about you guys, but every time I leave Washington, D.C., my friends make fun of me for all the acronyms that I use, like OMB and Oira, which I often throw out at cocktail parties, just so you know, very popular. I would like you, Satya, to talk a little bit about what those two things are. And then we'll have Brian chime in a little bit with how they interact with the Department of Health and Human Services. But if you can start us on what is OMB and what is Oira and why should I care?
So, yeah, this happens anytime folks in the same industry get together. There's a lot of jargon and a lot of shorthand and a lot of talking shop. So I like to think of OMB, the Office of Management and Budget. It's an agency within the Office of the President. And I like to think of it as kind of the nerve center for policymaking across the executive agencies, right? So each agency has its specialized mission, has very deep knowledge within those areas, but there needs to be some coordinating function at the White House campus that can sort of see across all the different agencies, make sure they're not working at cross purposes. Fundamentally, that happens through the budget process. So the B and OMB helps develop the president's budget annually. And that's an exercise to help see exactly what each agency is working on and how much resources are being put towards it. But within OMB, there was created in 1980 an office to specialize just on the regulatory policymaking process. So obviously, a lot of what agencies do involve spending money, involve program activities, but by some measures, 90% of federal policymaking happens through regulation. There's less and less legislation each year, but there's more and more rules that are issued by agencies. So there needed to be a central coordinating office that could make sure that different agencies, often which have overlapping jurisdictions, overlapping expertise, could make sure that those are coordinated, that they're all speaking with one voice, and that they comply with the president's overarching goals with respect to regulatory policy.
Very helpful. So like a central nervous system for our regulatory system. Brian, can you talk a little bit about your time at HHS and how you viewed OMB and Oira in their rulemaking function, how that impacted your work at the agency?
So I think the description of OMB and Oira as the central nervous system is a great one. I think HHS would be the arms and legs of the operation. They're the parts of the body that do the spade work of preparing the drafts of the rules, putting the rules out for comment, accumulating all of the comments, reviewing the comments, analyzing the comments, preparing the final rule, and then putting it back into the interagency process. They obviously do that with a lot of input and guidance, both substantive and procedural, from OMB and Oira. I think that when I initially arrived at HHS, I came to view OMB as the backseat driver of the federal executive branch. They always seemed to have an idea about how things should operate that was slightly different than what HHS thought should happen. But over the course of my evolution at the department, I really came to value the expertise they bring, and I came to value the intellect and the expertise of the folks at Oira in particular. They're able to pick up a rule, blast through it, and provide a host of substantive and procedural comments quickly and improve things. So I over time personally came to view them as a really great partner in any sort of rulemaking activity that I did. I think that they were the yin to the yang of the agencies, if that makes sense.
I think that gatekeeper is a very popular role. Just kidding. So let's dig into this a little bit more. I think that one thing that we talked about, how big of a mistake it is to overlook the role of OMB in an advocacy strategy. And I know that you both have a lot of thoughts about that, how clients can work with OMB and work with other stakeholders to help shape OMB's approach and work with HHS and sort of move around all the different moving pieces within Washington, D.C. Satya, I'll start with you. Talk a little bit about how now from the outside, you would talk to somebody about how to engage with the Office of Management and Budget in this rulemaking process.
So I think it's important to start fundamentally the agency's goals, the agency's initiatives are driven by the president. Now, the president is not going to read or write thousands of pages of regulatory text, but the president does have the authority to set an overall direction. That can often be explicitly through executive orders. It can be more implicitly through discussions with the cabinet and the cabinet secretaries. And when the cabinet secretaries are going through a confirmation process, that'll often signal at the kinds of conversations that the president may have had with those nominees. But once that overall kind of 100,000, 10,000 foot level is set, the agencies are responsible for drafting the policy, meeting with stakeholders in their domain, thinking through some of the budget implications and regulatory implications. So at the first instance, the agency is the place where pen gets to paper. Before anything goes public, though, it would come to OMB through Oira to coordinate and make sure, one, is the thing that you've actually put down on paper consistent with the direction the president has set, right? That direction may be very vague, very general. So we now have to kind of pressure test that and make sure, is this actually what was intended? Two, it goes through the interagency process, which just today, the FBI director was testifying in the Senate, and there was a long discussion with Senator Whitehouse about what does interagency mean. Before a binding policy document can go out, it has to go through an interagency process, which means that other agencies and other offices within the White House who may have an equity, may have a say or some relevant expertise or input are brought to the table if they want to say, here are our thoughts, here are our concerns. Why did you do it this way? How come you didn't choose option B versus option A? And Oira actually has a formalized process for the public to engage with that interagency process or alongside it. You can actually go to the Oira website. You can Google it. It's within the White House website. And you can request a 12866 meeting. 12866 refers to the executive order that's been in place for several decades. And that executive order requires that the public be given an opportunity to engage. And those meetings are scheduled for as long as I've known this process in the order in which they're received. There's no favor, no preference given for important people versus perceived less important or political entities or anything. They're scheduled in the order that they're received. They are obviously 100% done on Zoom and remote at this point. And the important thing to remember is that OMB will be there. The relevant White House offices are invited. Again, if they don't feel that they need to, they won't show up if it's just not something they're following. That could include White House Counsel, Domestic Policy Council, and so on, as well as other agencies that feel they have some kind of jurisdiction or relevant expertise there. And any materials that you share in those meetings are required to be disclosed. So they will be docketed and will be disclosed on that same website. But I guess contrary to kind of a lobbying meeting, which can happen sort of in the shadows, these meetings, because all the relevant parties are brought to the virtual table, it means that there's no kind of secret information that one party has and another doesn't. The whole point of the Oira process is to make sure everybody is seeing everything. And that's an opportunity to, once say a proposed rule is being drafted, to have a say on that. And those comments, information, as long as it's relevant, are considered public comments. At least Oira considers them public comments for the purposes of the rule, meaning that if I bring forth a relevant issue or a concern or data or some kind of analysis, Oira will insist that the agency have a response for why they didn't consider that or why they believe it's incorrect or why they have contrary data that shows something different. It's a public comment the same way it would be on the Federal Register.
So my sense of those meetings has also been that they tend to be more technical because they are driven by rule text. But I wonder if you have any insight there into sort of the type or level of information that's expected for that engagement.
So sometimes it can be amplifying comments that were made during a public comment period. So if say the proposed rule had already gone out, and now this is the draft final rule stage, the stakeholder, the commenting party may say, hey, we commented on this at the proposed rule stage. We want to make sure that it was given its due diligence and response. And also maybe since the proposed comment period could have been a year ago, 2 years ago, 3 years ago, there's new information. We want to update it and bring that information forward. So I think the best way to think about it is it does tend to be very highly substantive and somewhat technical. The role of that Oira process is not to weigh the costs and benefits of different political constituencies. It's to weigh the costs and benefits on the economic effects of the rule. So the best way to engage is to bring data. It's to note where costs and benefits may or may not be quantified. And Oira's job is basically kind of the green eye shade element of the White House campus. It's Oira only has at any given time 2 to 4 politicals, but it has up to 60 career staff, and that career staff is impervious to political arguments, right? Their job is to say, look, the president set a direction, the cabinet secretary set a policy direction. We're not here to argue whether that's politically important or a good idea. We're only here to say, have we fully accounted for the effects of this rule? Is there a way to do it better, to better accomplish the intended goal, or is the way that you've done it likely to have unintended effects? So those meetings also, it's worth noting, are listen only, right? So you're not going to get a lot of back and forth. Again, it's best to think of it like the comment period, right? You don't get a lot of response when you comment on a rule, right? You submit the comment, and then the Federal Register puts it up. It's docketed, but you're not going to have a conversation. This is an opportunity to do that, but in person, and you will get some questions, to clarify certain points. So in that sense, it's not just a rehash of your public comment. It's an opportunity for them to say, "Hey, I didn't quite understand what you meant by 20% of the industry is not going to be covered by this rule. How did you get that number?" Or why do you say that this new minimum requirement is not going to lead to any kind of cost reduction somewhere else? How did you arrive at that conclusion, right? There will be questions of that nature, but they won't be, which constituency is really going to like this rule and which one's not. They're not going to be those kinds of questions. And you're not probably going to get, this is just kind of a practical advice, you're not going to get a sense of, well, where was Oira after that meeting? They're going to be very stone-faced, but that's their job. Their job is to be sort of neutral arbiters of the evidence and make sure that all the parties within the government that have a role are at the table or invited to the table so that they're seeing the same information.
So this sounds very rigorous and interesting and like a good opportunity to express your thoughts and feelings about rulemaking, but I can also see on the flip side, Brian's backseat driver concerns. So throw a little bit of a curveball, but Brian, I want to hear a war story about, it can be good or bad, about how this has played out in practice. Pick your favorite Trump era rule and tell me all about it.
I would pick an example from the latter part of my tenure, because I think that's when I gained a full appreciation of the talent and the expertise and the value that the Oira staff brings. And basically, I had rules, more than one, towards the end of my tenure where there were moving pieces related to the economic analysis that you have to go through in order to get the rule out the door. There are analyses related to the regulatory flexibility provisions. There are analyses related to small businesses. There are analyses related to impacts on families, which are more qualitative and less econometric or economic. But Oira is a great partner for an agency that's trying to work through those issues and can usually help you as the agency lawyer reach a principled solution. You may have to modify the rule to fit it within the right field of play under the statutes, but Oira is usually able to help achieve that in a way that's principled and faithful to the statutes and existing regulations. So I can't really go into details on a particular rule, but I saw that multiple times towards the end of my tenure. Their focus on substance, enabling agencies to work those kinds of issues out. And I think having gone through that process, I now tend to look at engagement with the executive branch a lot like I looked at advocacy in the judicial system. If you're going to try a case against the government, you want to start with thinking about how an appellate court would look at the case. And you would want to back into that venue and then work forward into how you present the case at the trial court. I think advocacy in the executive branch is very similar. You want to think about how OMB and Oira are going to be applying the president's agenda, the substantive expertise they're going to bring, and then you want to take that into account when you're advocating at the agency, because at the end of the day, it's going to be OMB and Oira that are adjudicating any disputed issues within the interagency process related to those economic issues and a host of other substantive issues in a rulemaking. So that's a long-winded way of answering your question, but hopefully it's helpful.
Well, and let me just bring up, again, not a specific example, but almost across the board, someone may ask, why would one agency have something to say about another agency's rulemaking? Isn't that kind of, well, on almost every rule, DOJ has an equity, right? If the rule is going to be challenged, especially if it's taking a big swing and maybe it's controversial, there's going to be someone somewhere that's going to challenge the rule. And DOJ has a very primary hand in helping defend it. So their voice needs to be heard. Of course, HHS or any other agency has general counsels. They have their own solicitor sometimes, but DOJ needs to be heard in that process. That's an example of where DOJ and the authoring agency may have disagreement about the legal standing and how defensible a certain policy is. And OIRA would be the place where we would set up a resolution process for those two agencies to get to a place where both can say, you know what, okay, we can live with this. This is consistent with our knowledge and our expertise and our equity. And so we can go forward with the government speaking with one voice.
That situation occurred time and time again during the pandemic. Particularly whenever you had a rule related to the movement of people or things across borders, because Homeland Security's interests would be implicated, HHS's interests would be implicated, the Department of Transportation's interests would be implicated, DOJ's interests would be implicated, and sometimes agencies you'd never think of would have their interests implicated. And looking forward, I can see something like surprise billing presenting the same kind of broad interagency equities. You have 4 different cabinet departments that have been tasked with issuing rules to implement the No Surprises Act. And that's just the start. There's probably other nooks and crannies of the federal government that want to have a say in some way, shape, or form on that. And if you're going to approach it holistically, you've got to start with how the top of the executive branch is going to approach the rulemaking and work from there.
So that's a great pivot to our next little topic area around the current administration, the Biden administration. And I'm assuming that many of these same principles apply and the same types of dynamics across agencies working together or at cross purposes being brought together to try to work together. We've seen a little bit of action out of the Biden administration and how they're going to approach some of those Trump era rules and regulations and either repeal, revise, freeze. Brian, can you bring us up to speed a little bit in terms of where we are now with the Klain freeze memo, executive orders, and all that?
Sure. So the Klain memorandum was issued by Ron Klain, who's the chief of staff to President Biden. And to be perfectly candid, I don't think it's out of step with what happens at the outset of every presidential administration. I thought that there were some good things in it, actually. He said that only department heads should be signing off on new rules, which is actually a good thing. You don't want people farther down in the food chain at agencies signing off on rules. And that's something that actually the Trump administration pushed for, and I think prior administrations have always insisted on. So what the Klain memorandum did beyond that was say that if there's a rule pending at the Office of the Federal Register that hasn't been published, it needs to be pulled back. And if a rule has been published in the Federal Register, then you need to relax the effective date to allow for further consideration of the rule, which again is not out of the ordinary and is probably just good government for any incoming administration.
It's almost identical verbatim structurally to the last 3 transitions. Every incoming White House chief of staff has issued almost the exact same memo saying hit pause where you can, withdraw where you can, and give us time to review everything.
It gets tricky in applying the memo in some instances because you'll have rules that published the day after the inauguration by mechanics that we aren't privy to and may never fully understand. And there's questions about what you do in that situation. But if an NPRM has been published, usually it just sits and comments accumulate and the the new administration decides what it's going to do when all the comments come in. And if a final rule's been published, then the administration can push back the effective date and evaluate it as it deems appropriate. I think the more interesting questions spring from the Biden EO that revoked a number of the Trump era deregulatory EOs. And I find that interesting because it instructed the Biden administration to rescind rules implementing the Trump EOs. And a lot of the rules implementing the Trump EOs were procedural in nature. They related to the use of guidance documents. And some of them were put out without notice and comment, and some of them were put out with notice and comment. It's a lot harder to change a rule that's been put out by notice and comment because you've got to go through notice and comment. And it's hard to rescind a bunch of rules when you're trying to press your own agenda, particularly when those rules are procedural in nature and they're not substantive policies. So I haven't seen much activity in the way of implementing the Biden EO through rescission of rules. I guess it's not surprising this early, but it's something that I'm definitely tracking because I know at least at HHS, the good guidance rule that was put out through notice and comment has a pretty significant impact on agency operations and adjudications and regulated entities. So I don't know, Satya, if you have any more thoughts on that.
Well, in terms of the Oira process and kind of OMB's process, the fundamental operating kind of source text is where I referred to earlier, 12866, and that's an EO that was issued in 1993 by then Oira Administrator Sally Katzen. That EO has been upheld by every administration since and has generally become a widely respected and widely internalized set of processes and standards to apply to centralized review of rulemaking. So that still stands, and the Biden administration does not revoke that. So the core of the process is going to remain the same. It was not a big surprise. I think surprised literally no one that the Biden administration was going to revoke the so-called 2-for-1 EO. This is the EO that directed agencies to have to repeal 2 rules for every new significant one that they issue. That was obviously never going to kind of uphold in a Democratic administration. I was a little surprised to see pulling back of the guidance EO that Brian was talking about. This didn't really have a lot of new substantive standards, but what it said is at its core that all guidance documents, all non-553 quote policy statements had to be centralized on the agency website in a single index searchable way so that even a layman could go to the website and say, what are all the things that possibly could apply to me? And that they also conduct an audit, and for any guidances that have been issued in the past that are just no longer enforced, that have been replaced, that they be clearly marked as no longer in effect. And they keep a record of that so that there isn't confusion between, say, 2005 guidance and the 2012 guidance and the 2019 guidance, which, to Brian's other point, most of the attention of an agency, any agency in any administration, is doing new things, right? You don't, especially the incoming administration doesn't come in and say, let's spend all our time looking back and doing audits and doing retrospective reviews, right? They want to do new things. They want to put their own policies in place. And when there's finite resources, like finite staff and finite time, most of that effort is going to be on the new stuff. But what that EO did is said is this is administration policy that you have to do a look back. We have to. It's not sexy. It's not going to sort of win anyone any kind of like plaudits from the Oval Office, but there needs to be a systematic review looking back of things that may have been just floating out there and nobody bothered to formally pull back. So I think there's been some push to have the Biden administration reinstate the requirement that all guidance documents be online in a single place and be searchable. Because I think at a core, that's just a transparency measure. It doesn't seem that controversial.
Yeah, so this is a theme I think we've seen across the entry of the Biden people, which is how much time do you spend looking back and criticizing versus moving forward and implementing and sort of coming up with your direction. And I think they're walking that line, but it's a line, right? And we're seeing that across the healthcare space in terms of where do you devote those scarce resources, as you mentioned. We are reaching the end of our time for this conversation. I want to give you each a chance to give our listeners some advice when it comes to working with OMB or Oira. So your top tip in terms of engagement there, and I'll start with you, Brian.
I think the most critical thing is focusing on the substance. And it's very easy to get wrapped around the axle by focusing on politics. The politics are always important, but ultimately you have to tailor your argument to your audience. And I think when you're making arguments to OMB and Oira, the substance is paramount. I think ultimately the substance is paramount regardless. And so it's good to start out arguing substance at the agency. But I think just focusing on the merits is critical.
And Satya.
So as a preface, it's going to be interesting because Oira and OMB's prerogative, just like any other political office entity within the executive branch, is dependent on its political leaders and that person having credibility within the White House and within the Oval. Any decision, OMB, agency, or whatever, can always be overruled by the president, right? If two agencies disagree, ultimately, most things don't get to that point. It's a small subset, but ultimately the president can make that call, which way he's going to go to. And so OMB having a strong leader, Oira having a respected administrator that is respected by the president, the chief of staff, and those close advisors is going to be important. So that's going to kind of help inform how to engage. But again, think of Oira as less of having a dog in the policy fight and wanting to make sure that they survey everything. They have a consistent understanding of what the president wants to do and whether this incoming rule, this incoming draft is consistent with that. And that as said before, that the government's speaking with one voice. So like Brian said, be substantive, make sure that you've engaged at the comment period, at the proposed rule stage, but can think of Oira as like the funnel, right? And making sure that all the inputs can be included in the final product.
And I'll just mention for our listeners, depending on when you're listening to this, at the time that we are recording, there is no confirmation at the top of OMB. So we're still waiting in discussions about Tandon in the Senate. So we will stay tuned for that for sure. You guys, this has been such a great conversation and I've really enjoyed it. I would like for each of you to have a chance to share with our listeners where they can reach you. So if you don't mind giving us a website, email both, that would be wonderful. And Satya, I'll start with you.
Thanks, guys. Thanks for having me. You can reach me at sthallam, STHALLAM, at EQRX.com.
And you can reach me at bstimson, BSTIMSON, at MWE.com.
Great. And for those who want to reach me, it's mmcdermott at mcdermottplus.com. All right. Well, thanks, you guys. We really appreciate it. And we will look forward to having you both back and talking to you soon. Thanks so much.
Thanks, guys.
Thanks.
I want to thank you both for joining us for today's conversation. And thanks to our listeners for tuning in. For more insights and analysis on health policy, visit us at mcdermottplus.com. You can find newsletters, resource centers. You can find a tracker for the executive orders that we talked about today, and more podcasts on the policy and legislative issues that impact your business. For more insights on healthcare law and enforcement issues, visit MWE.com or McDermott's Health and Life Sciences News blog at healthlifesciencesnews.com.
This material is for general information purposes only and should not be construed as legal advice or any other advice on any specific facts or circumstances. No one should act or refrain from acting based upon any information herein without seeking professional legal advice. McDermott, Will & Emery makes no warranties, representations, or claims of any kind concerning the content herein. McDermott and the contributing presenters or authors expressly disclaim all liability to any person in respect of consequences of anything done or not done in reliance upon the use of contents included herein. Copyright 2021 McDermott, Will & Emery. All rights reserved. Any use of these materials, including reproduction, modification, distribution, or republication, without the prior written consent of McDermott is strictly prohibited. This may be considered attorney advertising. Prior results do not guarantee a similar outcome.